Welcome back, everyone, to the Deep Dive. You know we love to get into the weeds of some pretty complex legal issues here.
Yeah.
And today, well, we've got a real head-scratcher for you. It all revolves around a recent Supreme Court case that grapples with a really fundamental procedural question. And I've got our legal expert here to help us untangle it all.
Absolutely. This case dives right into the heart of when a defendant can pull a class action lawsuit out of state court and move it over to federal court. Specifically, we're looking at whether a company that wasn't originally named in the lawsuit but got brought in later through a counterclaim can then use the Class Action Fairness Act, CFT, as their ticket to federal court.
Okay, so let's set the scene here. We've got a class action lawsuit that started in state court, things are moving along, and then a new party, Home Depot in this instance, enters the picture.
Right. And it's not the original plaintiff who brought Home Depot in. It was the original defendant who filed a counterclaim against them.
And now Home Depot, they want to shift the whole case over to federal court. So the big question in front of the Supreme Court is, do they have the right to do that?
Exactly. We're going to be looking at how the justices grappled with the meaning of defendant in these kinds of procedural maneuvers and what it means for the scope of federal court jurisdiction.
All right. So let's start with the arguments made by the lawyer representing Home Depot, Mr. Barnett. He made a pretty straightforward case, arguing that under CAFA, any defendant who's facing a qualifying class action should be able to remove it to federal court.
And by qualifying, he's referring to the requirements set out in CAFA. So the case has to involve over $5 million, and there needs to be what's called minimal diversity, meaning at least one plaintiff and one defendant are citizens of different states.
Got it. So Mr. Barnett is saying that as soon as Home Depot was added to the case as a defendant on this counterclaim, and that counterclaim itself met those CAFA requirements, boom, that triggered their right to choose a federal court.
Yes. And he even bolstered his argument by highlighting some rulings from the 5th and 11th Circuit Courts of Appeals, which have allowed new defendants to remove similar cases based on the more traditional rules of diversity jurisdiction.
Now, the lawyer representing the other side, Mr. Blande, he's fighting to keep the case in state court. And his argument is really interesting. He's essentially saying that the whole power to remove a case to federal court hinges on whether the original lawsuit, the one filed by the plaintiff at the outset, could have been brought in federal court to begin with.
Right. His focus is on that initial filing. And he argues that when you look at the laws governing removal, the term defendant traditionally refers to those who were originally sued in that first complaint.
So his point is that when CAFA was written and Congress used the phrase any defendant having this removal right, they weren't intending to create this wide open door for removal.
Exactly. He's suggesting it was more about addressing a specific problem. You have a class action with multiple defendants, and some want to be in federal court, but others are blocking that move. He's worried that accepting Home Depot's interpretation could lead to this huge influx of cases into federal court, maybe even pulling in everyday state law cases just because a company from another state gets added to the mix later on.
Okay, so now we get to the really juicy part, the back and forth between the justices and the lawyers during oral arguments. Justice Sotomayor jumped right in and questioned this idea that every single defendant automatically gets their own right to removal.
Right. She pointed out that when a case is originally filed in federal court with multiple defendants, they all have to agree to remove it to state court. So she's basically saying if that's the rule for original defendants, why would a defendant who comes in later get this unilateral power to move the whole case? It suggests maybe the right to removal isn't as absolute as Home Depot is making it out to be.
And Justice Gorsuch, he zeroed in on what seemed like a bit of a contradiction in Home Depot's argument. He asked how you can have someone who started out as a plaintiff but then gets hit with a counterclaim and becomes a defendant on that counterclaim suddenly become a defendant for removal purposes.
This is where it gets really tricky. He's highlighting how the original plaintiffs, even though they're also defendants on the counterclaim, don't have the same right to remove the case.
So it raises the question of whether the definition of defendant is being stretched a little too far in this scenario, depending on what's convenient for the argument.
It's definitely a key point of contention.
Then Justice Kagan, she focused on this core concept of a civil action as a single unit. And she questioned this notion that adding a new party through a counterclaim basically creates a brand new civil action that's suddenly removable under the main removal statute, 1441A.
Her questioning seemed to suggest that the relevant civil action for removal purposes is still that original lawsuit the plaintiff filed. Adding a counterclaim, even one with a new party, doesn't magically transform the whole case into a new, independently removable action under the traditional reading of the statute.
Now, Justice Breyer, he really dug into the nitty-gritty of CAFA itself. Specifically, he zeroed in on how CAFA defines a class action as a civil action filed under Rule 23 of the Federal Rules of Civil Procedure, or a similar state-level rule.
And his question was this: can a claim brought by an original defendant against a third party like Home Depot really be considered a civil action filed under Rule 23 for the purpose of CAFA removal? It seemed like he was leaning towards the idea that the class action we're talking about is that initial suit filed by the plaintiff, not the subsequent counterclaim against Home Depot.
Now, Justice Alito, he took a slightly different approach. He wondered if, in a practical sense, Home Depot isn't still a defendant in the grand scheme of the lawsuit, even if they weren't there at the very beginning.
Right. And he also went back to the historical understanding of original jurisdiction in diversity cases, which is where federal courts have the power to hear cases involving citizens of different states.
So he's probing this question of whether we can apply a more common sense interpretation of defendant in this situation.
And he was also trying to get at the core purpose that Congress had in mind when they passed CAFA in the first place.
And finally, Chief Justice Roberts, he focused on this one word in the removal procedures, proceeding, specifically in the section that outlines how removal works.
His line of questioning was exploring whether the claim against Home Depot, even if it's not a standalone civil action in itself, could still be seen as a separate proceeding within the overall case. And if so, could that make it eligible for removal?
Okay, so we've covered the legal arguments presented by both sides. Let's shift gears now and talk about the policy arguments that came up. Mr. Barnett, who was arguing for removal, really emphasized the importance of giving every party who's named as a defendant in a case their opportunity to have their case heard in federal court. Assuming they meet the requirements, of course.
Yes, he was advocating for a broader reading of the removal laws, and he cited this idea that federal courts have an obligation to exercise their jurisdiction when it's legally appropriate. He didn't want the court to interpret the removal laws too narrowly.
And he also tried to assuage those fears about a potential deluge of new cases flooding into federal courts if they ruled in favor of removal in this situation. He pointed to what's happened in the 5th and 11th Circuits, where similar rulings haven't seemingly caused a huge spike in their caseloads.
Right, he's saying, look, it's not going to break the system.
On the flip side, Mr. Blande argued that CAFA was very carefully crafted to address specific problems within class action lawsuits. And he was adamant that it wasn't meant to just throw the doors wide open and pull every class action with an out-of-state party into federal court. He stressed that foundational principle of original jurisdiction and argued that the power to remove should be tied to that initial lawsuit.
Exactly. He's warning about the potential unintended consequences, the ripples that could spread out if the definition of defendant for removal purposes is expanded in the way Mr. Barnett suggested. He argued that if Congress had intended such a dramatic shift in where these kinds of cases are heard, they would have written that explicitly into the law.
Okay, so we've walked through the arguments presented to the Supreme Court. Now comes the fun part. We put on our imaginary robes and take a seat in that 10th chair. If we were up there on the bench listening to all of this, what would our take be?
From that 10th chair perspective, a few key points really jump out. The historical understanding of removal jurisdiction, it's always been grounded in that initial complaint filed by the plaintiff. The question has always been, could that original case have been brought in federal court? And allowing a party who comes in later through a counterclaim to then have the power to remove the entire case, it feels like a departure from that longstanding principle.
And when you look at CAFA specifically, the way it defines a class action is tied to a civil action filed under Rule 23. The original lawsuit in this case, it fits that definition. The claim against Home Depot, while it's part of the broader legal fight, it's not the action that was initially filed as a class action under that rule. So trying to fit it into CAFA's removal provisions, it just feels a little forced, doesn't it?
It does. And we can't ignore the potential consequences of expanding federal jurisdiction as broadly as Mr. Blande was cautioning against. If any defendant added later through a counterclaim could suddenly trigger removal just based on diversity of citizenship, it could really upset the balance between state and federal courts. And it might even incentivize more forum shopping, where plaintiffs try to strategically choose a court they think will be more favorable to them.
So putting on our 10th chair hats, the argument against allowing removal in this specific scenario where Home Depot entered the picture through a counterclaim seems to have a stronger basis in the way the law is currently structured. The text of the statutes, the history behind removal jurisdiction, and the specific language and apparent purpose of CAFA all point in that direction. Now, it's true that Home Depot is definitely a defendant in the everyday sense of the word, but for the very specific purpose of removing a case under CAFA, that link back to the original class action lawsuit seems to be a crucial factor.
I think that's a great analysis.
Well, there you have it, a deep dive into a truly complex legal question. As you can see, figuring out who qualifies as a defendant with the power to move a class action to federal court under CAFA is way more complicated than it might appear at first glance.
The justices had to really grapple with the precise wording of the law, consider years of legal precedent, and weigh the potential real-world impacts of their decision.
Now, we want to hear from you. What are your thoughts on all of this? Does it make sense to you that the original lawsuit should be the deciding factor in determining removal? Or do you think that any party facing a class action claim that meets those CAFA criteria should have the right to have their case heard in federal court?
This case really highlights the constant tension that exists between the powers of state and federal courts, and the challenges that often arise when trying to figure out what Congress intended when they wrote these laws.
Absolutely. We encourage you to think about how this decision could potentially impact class action lawsuits going forward and the broader rules that govern how civil cases move through our legal system. Thanks for joining us on this deep dive, and we'll see you next time as we explore another fascinating legal puzzle.